Hello and welcome to the podcast Law for the Lay, a new game to play. I'm your host Clarissa. I'm an Australian lawyer living in the UK and taking on the entertaining challenge with guests on this show to make sense of all the laws that apply to us here on planet Earth as we navigate this game of life. Today's guest is Riya Jain. I discovered her on Instagram when she commented on my post regarding Aboriginal customary laws in Australia, and she gave me the heads up she'd written some papers on legal pluralism in India and Jordan, and we both agreed legal systems can be improved beyond what they presently are. These papers are linked in the show notes, and Riya will explain legal pluralism in a moment. By way of background, Riya is a recent graduate of Johns Hopkins University, where she studied economics and political science. While in school, she was awarded the prestigious David L. Boren Scholarship to study Arabic in Amman, Jordan for a year, and her experiences abroad inspired her research on informal legal systems and alternative dispute resolution mechanisms. Riya currently lives and works in Washington, D.C. and will be attending Harvard Law School in 2024. So exciting! She is passionate about international development and hopes to improve the rule of law and access to justice in countries around the world. Now, just before we jump into the interview, I want to point out that when I asked Riya on Instagram if she wanted to be featured as a guest on this podcast, she was enthusiastic given she knows her stuff in this area, but she did express reluctance given she wasn't a lawyer. So, to clarify this for both my audience and future guests, Law for the Lay is a podcast for everyday people, whether you're a lawyer or not. I intend to have a mixed range of guests for the benefit of my audience that can make a valuable contribution to this journey we are on in the game of life. This isn't legal advice, it's legal education. Or as I like to poetically put it, it's legal enlightenment. So, back to the podcast. Enjoy meeting Riya, who's someone I firmly believe will be a leader in lawland well into the future, as we discuss when the game needs to change with legal pluralism. Hello, Riya. Thank you so much for joining us here on Law for the Lay.
Glad to be here. Thank you for having me.
Without further ado, tell us something that you love that's silly.
Sure. I absolutely love ice cream, and I know that everyone loves ice cream, but specifically, and as my friends would say, I like more pretentious flavors. So at the gelato shop near my house, I recently had one that was called lemon ricotta cardamom, and it was
Oh
absolutely
my
delicious.
God.
I have a box of lychee ice cream sitting in my freezer right now. And I think ice cream is just such a cool way to explore different local flavors, especially when you're traveling. So I love ice cream, and I like fun and unique and quirky flavors.
That is amazing. I love that. I'm curious, what makes an ice cream more pretentious? Is it just more descriptive words attached to the first name of lemon?
I think so. I think you can have, like your cookies and cream, which is always delicious, or you can have a blueberry lavender, which perhaps is more pretentious.
That sounds insane. I want to try that. It sounds like something out of Willy Wonka's factory.
It's
Oh, that's
really good.
gorgeous. Okay, so on to the more serious side of the podcast in terms of legal pluralism. So, as a backstory for our audience that are trying to wrap their head around legal pluralism in itself, there's one important thing to note with legal systems all around the world. And I pretty much allude to it in my introduction for Law for the Lay, in that the game of life is difficult enough to navigate as it is, but there are different rules that apply in different countries, sometimes multiple overlapping rules in all of these countries, and it can get overwhelming. So, as a big overview, throughout the world, there are legal systems that are common law legal systems, which they establish precedents, and these are binding agreements with everyone in society saying, okay, that was a decision made back then, and we'll look at that for future decisions. And then there's civil law legal systems that have codified rules that everyone can look that rule up and be like, okay, I know what to do in that situation. There's also religious legal systems and customary legal systems, and it can all get a little bit crazy. For example, if you move to Dubai, there is a civil law legal system, and there's also the Sharia law legal system. So that is just one example of all the different things coming together. So, Riya, would you mind explaining for our audience what legal pluralism is?
Absolutely. So that was a fantastic sort of background and introduction. Legal pluralism is essentially the coexistence of two or more legal systems in one country. So in the countries that I've studied, Jordan and India, it's the coexistence of tribal law or customary law and civil law. And, I'll preface all this by saying that that civil law is always better for handling complex, sophisticated issues that only the state has the resources to resolve, like taxation or intellectual property, labor, immigration. However, when it gets blurry, when both legal systems come into play, is for more petty personal or minor criminal cases. And legal pluralism is very apparent in post colonial countries like Jordan and India, where tribes in Jordan and villages in India practice customary laws that are set in place by centuries of tradition and cultural norm. And then when they were colonized in the 19th and 20th century, the British or French legal system was then exported, creating a new formal legal system that's practiced by the state. But it also affects developed countries like the United States and Australia. So you've got Native Americans and Aboriginals in both countries that have their own legal systems that exist alongside the formal law. And so, what I think is important to understand about legal pluralism is that it's not an unfinished stage of legal development or national development. And critics would argue that legal pluralism is bad because having a competing legal system that isn't sponsored by the state can often undermine the state's ability to effectively dole out justice in a country, and it can undermine state sovereignty. And in many respects, local tribunals are often inequitable and inconsistent. They are ultimately decided by people who may not have formal education, let alone legal training. And they could apply the law inconsistently because ultimately it's been passed down by oral tradition and it's not written down. And yet, at the end of the day, statistics say that an estimated 80 to 90% of disputes in the developing world are handled outside the state justice system. And that means that there is either a preference for or a need for the customary laws, and it persists for a reason. And that's the sort of understanding that my inquiry into legal pluralism started from.
Wow, that is like incredible. So, for our audience to have a practical example, what would be a situation where two legal systems might come head to head with each other?
Sure. So in India, the legal system is very overburdened. So let's say there was a minor car crash or something, you could get that resolved in a state court, but it could take a very long time. Also, if you're from a village or a more rural area, maybe you don't speak English and you're not as educated, you don't have as much money, you might get it resolved through the local village legal system because it's a minor transaction. In Jordan, for example, often crimes that involve honor or shame are resolved by the tribes because they have systems and customary laws in place that resolve those issues in a more just way for the people there.
And that's really interesting because it parallels slightly. I mean, obviously, there's very different customary things at play in every different country. But with Indigenous culture in Australia, I learnt recently on a trip to Alice Springs in February that actually occurs in some Indigenous proceedings where there is that element of shame, and the person who's committed a wrongdoing, as part of the cathartic process of legal justice, is they have to apologize to that person. But the interference of customary law and common law doesn't always work that well together sometimes, because the common law will come in and be like, we're going to deal with them in this way. And, a lot of Indigenous cultures have dealt with things in their own way for a long period of time before common law came into Australia. So it is quite tricky. And it's one of those things that, it's a part of their identity and how they will administer justice. So it's incredibly complex and something that
Yeah.
I certainly wasn't taught at university in great detail.
And I'll give you one really concrete example. So in Jordan, part of tribal law is this practice called Jalwa, which is essentially a forced separation. So if, for example, there's been a crime against a woman, then the perpetrator and 5 generations of the perpetrator's family must leave the tribe, go elsewhere, they're banished. And that centuries ago was really problematic because that was dishonorable, it was shameful, and living outside of the tribe without that social solidarity was incredibly difficult. So it was both punitive, but it also kept peace. Today, the law has been revised so that it's just maybe the perpetrator and the perpetrator's father or brother, and that is sent away, and that's essentially to separate the feuding parties. It prevents revenge, further bloodshed, and it's this sort of communal sense of responsibility, which runs directly adversarial to the civil law system, which ascribes guilt to one person, the perpetrator. It doesn't involve the perpetrator's father or brother, because there's a notion of individual guilt and individual responsibility. And yet, that doesn't work for maybe some people in Jordan because they feel like the family is responsible, and then it could perpetrate even further bloodshed if the family isn't punished. So that's how two different notions of justice are resolved differently, and one ultimately could keep the peace and the other couldn't.
It's an incredible concept, isn't it? Particularly when it's such a huge influence from the family structuring that, it's, I mean, obviously everyone should be incentivized not to do the wrong thing. But if there is a major pressure from your family, it would probably diffuse a lot of things from committing certain crimes. And when you were explaining through that, because I remember reading your articles, which are brilliant, by the way, but I was trying to think of
Thank
it
you.
in a concept of my own understanding. And I was like, okay, so what if like a footballer commits a sexual assault in Australia, which has happened, and their entire family has to move away somewhere? It is a bizarre concept. It genuinely is. And culturally, it's something I'd love
It
to
is.
immerse myself in to understand better. But, in a lot of Western civilization, like, even policing that would be very difficult to do.
Definitely. And that's the fundamental difference as well. In Jordan, it's because, the basic unit of identification is the family and the tribe, especially in more rural and southern parts of Jordan. And so you can't simply ignore those social structures that are in place and run very, very deep. And yet, civil law doesn't necessarily address that.
Yeah, absolutely. Oh gosh, there's so much we could cover here, but just to keep it simple for our audience, based on both your research and the academics that you've spoken to write your papers and things like that, is there common issues that you're seeing with countries that are trying to implement legal pluralism?
Definitely. And I would say, legal pluralism already exists. I mean, there are already two or more legal systems coexisting. So it's more of a matter of how do we improve it. And I would say, one common issue is that formal legal systems of justice are not yet adequate. In Jordan, the courts are currently too weak to keep stability in a lot of cases because if people feel like they haven't received justice or that their honor and their family's honor hasn't been restored, then the incentive for revenge and further bloodshed is still there. And so ultimately, justice wasn't achieved. And so oftentimes tribal leaders are very powerful. They garner a lot of respect and they are able to prevent revenge and they're able to keep peace faster than the courts can. In India, the issue is similar. And they need to be strengthened insofar as the courts are wildly overburdened. I read a statistic somewhere saying that if judges in India were to dispose of 100 cases every single hour, it would still take 35 years to fully fill the backlog of cases.
Oh, wow.
And, it's not surprising. It's a country of 1.3 billion people. It can take 30 or more years to resolve a case, at which point it's a case of, too little, too late. So formal systems of justice, the court system, needs to be greatly strengthened before they can sort of fill the state role that they're meant to fill. And I would say across the board, another common issue is that the formal system also just lacks popular legitimacy. So when people feel like the courts don't reflect their culture or that it extorts their time and their energy and their money, they
Mm.
don't feel that the system is just. And that's the point of the law, right? Is to develop justice to the people that it's serving, not justice according to the British or to the Americans. And so, as long as customary systems appeal to people's sense of justice, they will continue to persist.
It's really fascinating, isn't it? It's kind of like an unspoken bond that, like, customarily, if people respect the law better, they're more likely to respect it and oblige by it, as opposed to just being like, oh, there's this, big dog law over there. I should probably pay attention to at one point or another. But it is, yeah, it's something that we almost need to, take a pulse on it, I guess, throughout both people's legal education, but also as a society, and seeing, what people are doing well in certain areas and what can be implemented. Particularly as you, as a student, you're going to be at Harvard University at one stage, wherever you take your profession. I mean, you're already incredibly switched on to this kind of thing, and you're going to probably do incredible things in your career. But I'm also thinking about all the other graduates, all the other law students that are spitting out all over the world, and just general lay people who may want to improve systems, whose families may have been affected by, injustices within the legal system and things like that. There is so much room for innovation. And India is a place where it is known to be booming in technology and startups. And there is so many things that are going to get better with time there. And, the same with a lot of Western countries as well. There is ways that we can administer justice better, utilizing technology, utilizing new brains, fresh ideas, all sorts of things like that. So I really can't wait to see the evolution of this and to see where we can get into better ways of doing things, because the definition of insanity is doing the same thing over and over again and expecting a different result. And, quite frankly, I did a little bit of research into the Indigenous customary laws in Australia with our common law systems. And it's over a long period of time, it just hasn't been working. And I feel like it's something that I'm quite passionate about, to encourage students and teachers and people to get involved in these processes so we can improve it just for future, and also to preserve culture, because that's also really important.
Definitely. And I think a lot of people don't realize when we think of the law, we think of courts, but there's also alternative dispute resolution mechanisms, and there's a lot of room for
Exactly.
innovation there. There's mediation and conciliation, and there's different ways to resolve an issue, and it's all under this big umbrella of like justice and the law. So definitely a
Exactly.
lot of room for innovation.
Exactly. And the alternative dispute resolution, like, society should incentivize getting better at that, because it's more cost effective and people need to pay lawyers less. And I mean, obviously the legal community is going to string me up for that one, but like, it will actually be more affordable for people to administer justice if they can afford it at the end of the day.
And I'd also say it's also more flexible because in the court system, there's a very limited number of options, as far as I understand, at least for the punishment. So it's either jail time or in extreme cases capital punishment, maybe some kind of volunteer time.
Yeah.
But with mediation and conciliation, the ranges of solutions are really much larger. It's whatever two parties can come up with and agree upon. And so, for example, the solution of Jalwa, that forced separation in Jordan, is just an example of another way to resolve a dispute.
And that kind of leads perfectly into my last question for you today, which was, in terms of, like, I guess it's like the positive side of legal pluralism. What are the things that we could be doing in future to improve this area, and playing a role from an advocate perspective?
I would say that first, there are probably like two challenges that I would point out. The first is international acceptance. I think it's really easy to look at a practice like Jalwa, for example, and say, that's really backwards. That doesn't make any sense. But, if you read my paper and maybe do a little more research into it, you can understand the cultural reasoning behind it, and why it
Context.
persists. And then I would say the second is this challenge of future trends. So, with technology and urbanization, people are forming new communities outside of their traditional cultural tribe, family, or village. With immigration and refugee inflows, particularly in Jordan, new people are coming that have different value systems. And that puts an increasingly large pressure on legal pluralism because it customary laws depend on people feeling connected to their village or their tribe and to centuries of legal tradition. So I would say, with that understanding sort of moving forward, um, one thing to improve legal pluralism is definitely to strengthen the role of the state and make sure that they are able to keep peace and not rely on tribal leaders to do that, to ensure that the courts are able to effectively get through cases so that they don't have to rely on the villages to do that. And I would say another role and thing not to ignore is sort of greater oversight, because it is definitely true, especially in South Asia with the village systems, that there is often human rights and women's rights abuses. And so creating greater oversight to ensure that that these systems are still recognized as valid and effective, um, and yet not perpetrating greater human rights or women's rights abuses. I would say definitely take a note from India's playbook. The Lokadalit system is based off of the traditional village customary law system, and it is an extremely effective alternative dispute resolution mechanism. It is completely free. It is very quick. Oftentimes, cases are resolved in one day, which is
Oh,
a
wow.
massive
That
improvement
is
over
unheard
30
of.
years. Right? And the people who preside over the cases are often a retired or practicing judge, a lawyer, and a social worker. So it ensures that the people who are presiding over these cases are both informed but also culturally attuned. It's very low infrastructure and can be conducted in any language. So it's incredibly accessible for people who don't have education, money, or live in rural areas. And so I would say it's an incredibly effective system. And this is an example of taking the traditional village panchayat system in India, updating it so that it follows international norms and accepted practices, and yet exists as an alternative to the formal legal system and the courts.
Well, it's certainly going to be a great place that can watch innovation happen. And it'll also be really good for anyone that's going into this area to not only use it as a case study, but also draw inspiration for it. I mean, this is all incredibly important, whether you reside in India, Jordan, Australia, anywhere that has legal pluralism at play, because it's getting everyone a little bit more woke. And whether you may or may not reside in that country, but if you travel there, you will be subject to the laws in that country. So everyone should be paying attention. Everyone should be at least upskilling in one way or another, and having an appreciation for it and how complex this little world that we live in is with this legal pluralism at play every day. Well, Riya, thank you so much for joining us here on Law for the Lay, and all the best in your studies moving forward. I can't wait to see where your career takes you.
Thank you so much. It was wonderful meeting you and really happy to be on today.
Thanks for joining us here at Law for the Lay. If you enjoyed this episode, I'd love for you to swing it around your social circles and feel free to connect with me on Instagram, TikTok, and YouTube at Law for the Lay. I'm always open to your feedback and content suggestions. Please also remember this disclaimer that no Law for the Lay content should be taken as legal advice. This is simply general information intended for educative purposes. Laws change all the time, and your personal circumstances may apply differently to what is discussed. So always do your research and contact a legal professional if you need assistance. In the meantime, look after yourself, look after each other, and let's have a good time.